This is Head Notes, a podcast from Whitehead Moncton.
Welcome to this edition of our Head Notes podcast. Today you're joined by myself, Antonio Fletcher, head of the employment team at Whitehead Moncton, and Veronica Fox, who's our senior HR consultant within Eclipse HR. The topic for our conversation today is the prevention of sexual harassment. That's triggered, not only by the changes that happened back in October 2024, but more change on the horizon as part of the wider employment law reform brought about by the Employment Rights Act that has recently become law, that will affect how sexual harassment is dealt with within workplaces moving further on into this year. So when we talk about sexual harassment, I think the best starting point really is to think about, well, what are we actually talking about? What is the definition of sexual harassment? Sexual harassment is any unwanted physical, verbal or non-verbal conduct of a sexual nature that has the purpose or the effect of violating a person's dignity or of creating an intimidating, hostile, degrading, humiliating or offensive environment for them. And it's important to be mindful that we can only be talking about a single incident. It doesn't have to be a series of conduct as well. I suppose the temptation up until a few years ago would have been, well, why is this a problem? Why are we talking about this in 2026? But actually, there's been lots in the news and lots of talk on an almost daily basis of conduct within workplaces and more widely that actually shows that this is still very much a live issue in modern society.
Absolutely, Antonio. I mean, I found some interesting statistics that ACAS noted, and going back to what you were talking about, the introduction of legislative changes in October 24, the Worker Protection Act. ACAS noted a 64% increase in employer inquiries in that quarter when it was implemented, of which in that period 58% of women experienced harassment, but only 45% of businesses at that moment in time had implemented staff training. And I think, as you and I have discussed in more recent times, that percentage figure hasn't actually increased that much. We're seeing that from reports, around 50% of organisations have an awareness of the legislative changes, not just in October 24, but also what's on the horizon under the Employment Rights Act.
Yeah, and that's quite scary on a number of levels. I mean, obviously, for individuals who are not, let's say, being particularly well looked after by their employers when it comes to this topic, but also for the employers themselves, because the impact of getting these kind of things wrong is quite severe on a number of levels, because as we said, there's been lots in the news, lots of stories about lots of organisations, multinational companies, across a range of sectors where sexual harassment has been an issue for them, and obviously it's led to a lot of negative press for them. It's probably led to people thinking, do I want to work for this organisation? It's led to people thinking, do I want to endorse this organisation with my custom? And that is aside from the potential ramifications of losing a case in a court or tribunal on these kind of grounds.
I mean, it also, what that flags as well is for the employees that are in that organisation, will they be confident enough to actually raise concerns in the first place, which really saddens me as a HR professional at that thought. But as you say, that sadly is still ongoing in many organisations. And we always look to encourage fostering an open culture, and that certainly wouldn't if somebody doesn't feel that they can speak up or have the tools to do so.
Just going through what actually sexual harassment might how it might manifest itself. Let's put it that way. Now, obviously, we're talking about physical conduct, even from more extreme things like pushing and grabbing someone, to conduct that some people might see as playful, but obviously isn't accepted in that way by everyone, and does then cause the recipient to feel violated. And there's a lot of education, I think, still with people around what should be acceptable on a physical level. Other examples include continued suggestions of sexual activity after it's been made clear that such suggestions are unwelcome. That's, I think, again, sort of something that hopefully would be on the more obvious end of the scale for people, that if you're propositioning someone there pushing you back, then hopefully most people would accept that, but clearly not everyone does.
Or if there's no reply, or if there's an awkward reply. I think that's the key, is to understand the communication that's been replied to. And relationships start often at work, and that happens. That's the way the world goes round. But actually really understanding the boundaries, that's not always particularly welcome. And I think you and I often see that more so than anything else in this particular topic, sadly.
Yeah, absolutely. Whether it's mixed messages or just a reluctance or inability to accept the messages that are coming your way. I think there's a lot of education on that needed, I think, within the wider population still. Sometimes when we talk about training the workforce, sometimes actually, rather than the key messages of where to direct and what's acceptable and what's not, it's actually that there may well actually be a wider need for training on soft skills, if you like, and actually understanding what people are saying to you.
And also just focusing on the fact, is it an abuse of trust from somebody, and that can be somebody perhaps that's more senior. An area that I'd always encourage staff is, if they witness, or if somebody confides in them, is actually giving them a voice to actually encourage that individual to speak out. Because the likelihood is if they're a victim of unwanted attention, the likelihood is that they possibly won't be the first, nor will they be the last.
Yeah. I mean, I've come across a number of cases over the years where there is, an imbalance of power, and actually you see them being dealt with in very different ways. That hopefully we're moving to a clearer understanding within society of what is acceptable and what is not. I mean, we've got other examples that we could talk about, including things like sending or displaying material that's either offensive, pornographic, things like that. And that can be in any form. It can be in emails, text messages, video clips, etc.
And WhatsApp messages as well.
And WhatsApp messages, yes. That's, always be mindful that people may well be sharing things with colleagues that aren't through the normal workplace channels. And certainly, I mean, if anything like that was going on, you'd hope that they certainly weren't going through the normal workplace channels for a number of reasons, regardless of whether it was welcome or not. But again, I think where we're talking about things like that, it's hopefully most people would understand the inappropriateness of sending material like that to colleagues. But we do live in a changing society where a lot of messaging and communication takes place electronically now, perhaps without as much control as people would want.
Or a more relaxed style.
Yeah.
Where perhaps individuals forget their own boundaries.
Yeah.
And I think particularly from your expertise, even if it's outside working hours, if the common denominator is work, then actually, even though that might be your own personal device, and it could be personal numbers, actually that does cross the line and cross the boundaries into a working environment, because the common denominator is your work colleagues.
Your work, yeah, absolutely. Obviously, other examples include unwelcome sexual advances or suggestive behaviour, which, as sometimes the harasser may perceive as being harmless, but it's all about how are they received by the recipients in those words. And clearly, obviously, offensive emails, text messages, or social media content are other examples, and it's fit very neatly in with what you were saying, actually, that if, regardless of whether it's a Facebook message or a tweet or whatever else, if the common denominator there is work, then, actually you've got to be mindful that may be going on as an employer, and send out very clear messaging. So we talked about, mentioned very briefly the changes that were introduced in October 2024 around sexual harassment. Those were an overspill from the government that had changed a few months earlier, and they sort of placed additional obligations on employers to prevent sexual harassment in the workplace, and follow the high-profile media incidences and campaigns that had taken place. And they placed an obligation on employers to take reasonable steps to prevent sexual harassment. And that was a big shift compared to what there was before. And very much at the time it was clear it wasn't about having a paper trail. It was actually about taking proactive steps to prevent, which wasn't really something we had in law before then. So that was a step towards what we're working towards now. But it was, when the new government came in, they were quick to say that actually they didn't think that was enough. Hence why we now have further changes on the horizon now.
I know, coming up in October of this year, 2026, there'll be steps expected in terms of taking all reasonable steps in terms of preventing sexual harassment and what that looks like as well. So if I just give a couple of key points that I think we should all be looking at as employers is conducting risk assessments.
Yeah.
And I've seen sensible employers have actually involved their employees to ask them what that might look like. Absolutely. And that could be something as small but important as changing the lighting situation outside in the car park, so that somebody feels safe. So there may be things that an employee might see that necessarily the employer doesn't, as in the more senior management. So do engage with the with employees, and I think in that sense it's fostering an open culture, asking what that is. Many employees may be able to sadly draw on experiences of what they may have witnessed in the past or heard about, so that actually looks to prevent sexual harassment. I'd also say training of managers to equip them with the skills and understanding of how they deal with this tricky and difficult situation that could arise, but also staff know how to actually raise concerns and who to. What the options are if they are concerned or if they have concerns for other employees or an employee that may be suffering from unwanted conduct or behaviour.
Yeah. I mean, I think the concept of risk assessments is very much a key one, and actually, hopefully, it's something that employers are relatively comfortable with, because they will be used to undertaking risk assessments from a business perspective generally, but also, looking at more specific things, health and safety, legislation and assessments are very much, sort of undertaken on a risk assessment basis. And I think it's a very similar kind of exercise that we're asking people to think about here when it comes to sexual harassment is actually thinking and digging down and thinking, well, what could cause harassment of any kind, but I mean most specifically of sexual harassment for the purposes of this conversation, to arise within our workplace. What are the risks? Are there risks of so someone working alone? Are there risks of a bar worker, for argument's sake, in a hospitality context, having to deal with a certain kind of clientele that may have had a few drinks and things like that? Are they at greater risk? Are security staff, for argument's sake, not necessarily someone that you'd think of in the first instance from a harassment context, but when they're dealing with people who might be particularly irate or unhappy with a not being allowed to access a premises or something like that, what could happen to them in terms of just the harassment side of things as well.
And not forgetting third-party harassment as well.
Exactly, and that's where these rules and these changes in 2026 will focus quite heavily on third-party harassment, and not only from the sexual side of things, but also, looking at harassment from the perspective of race, sex generally, religion or belief, and those kinds of elements, or sexual orientation, and the kind of harassment that people might be subject to on that basis. Now, it's hard to control what a third party does, but in circumstances where you're being asked to take as an employer all reasonable steps to try and avoid that, you've got to think about it quite thoroughly and try and anticipate everything you can, and whether that's signage, whether that's things in your terms and conditions of business, whether that's having really strict rules about if you harass our staff, you will not be allowed in this establishment ever again, and sort of spelling out these clear consequences that hopefully deter people. As well as taking those practical measures like, ensuring that there's lighting, ensuring that people aren't left alone, ensuring people aren't put in vulnerable positions, and steps like that.
I have seen some employers who've already started to introduce that onto their websites.
Yeah.
So again, that's just really supporting the fact that this isn't something that they will tolerate for their, particularly around a third-party harassment, that their staff having some form of third-party harassment, and that they're subject to that. And I think that just sends a really clear message as well, not just to the person that it could potentially be a perpetrator, but also to the staff to say, actually, we really take this seriously, and we support you, and we're doing everything that we can think of to take all reasonable steps to prevent sexual harassment, or, as you say, harassment in other guises as well.
Yeah. I do think it's fair to note at least that, from the employer's perspective, this can now be seen to be actually quite a risky area in terms of claims, because I think one observation that we can make now is actually we seem to be tracking a lot of what has already been done in Australia around sexual harassment. And one interesting point that I read in preparing for this was that actually where a similar threshold already exists in Australia, there's no examples in case law yet of any examples where sexual harassment has been found to have occurred, but that the employer has been able to rely on as being that they have taken all reasonable steps. And that to an extent is logical, because if sexual harassment has occurred, the starting point is, well, what could have been done to prevent that? Was it simply that the individual was not left on their own? Was there that a door was locked or a sign was up or anything like that? And if any of those steps could have prevented it, then the employer's on the back foot, where the requirement is all reasonable steps. So I think employers will face an uphill battle here to defend claims where there is sexual harassment that has taken place, or probably harassment of any kind, as the law develops. And from that perspective, it all goes back to, being really comprehensive, evidence-based, and having thorough systems in place to try and prevent this, whether we talk about risk assessments, training, policies and procedures, and all the steps that are necessary to prevent third-party harassment as well.
And also the key there is, we've talked about it can be one incident alone.
Yeah.
However, if there's any type of inference that something's afoot that shouldn't be, that staff, that you've supported your staff to feel empowered to actually raise it, because something that could be, I don't want to say nipped in the bud, because some things can't necessarily be nipped in the bud because there's severity.
Serious, yeah.
But however, that there's enough confidence that staff do feel supported, that they can raise the concerns, whichever channels they feel comfortable doing so, so that it doesn't manifest itself into a culture and to a toxicity that I think sadly we've been seeing in the press, all the negative things that have been happening for many, many years and decades.
Yeah, and I think it's important for employers of all shapes and sizes where, let's say you've got autonomous units, whether they're, a store with a store manager or a team working on a particular site or project, that those managers are monitored and are not just trusted and fully left to their own devices. Those need to be people who are trained and empathetic and understand their responsibilities and don't place employers in these situations by their own conduct or by their own inaction in not dealing with circumstances that arise under their watch, if you like. I think it's important to if we're sort of talking a bit more practically around, well, what does this look like? Unfortunately, it sounds very much like the guidance around what's going to be considered to be all reasonable steps will actually follow the legislation. So we're going into it a little bit blind when this does come into effect in October. But when we look at training, I mean, even now, any training that you give to staff, you need to make sure that there are several outcomes from that people understand what is meant by discrimination and harassment and sexual harassment, that there are clear statements of what the accepted level of behaviour is, trying to determine what's acceptable in the grayer areas like banter and things like that, and also obviously knowing what to do if either you experience harassment of any form or someone comes to talk to you about it.
And also new employees coming in.
Yeah.
There could be something where an employer has really focused on sending the message out in a really constructive, positive way around all the points that we've touched upon, but it's keeping that momentum going so that anybody new into the organisation or a new supplier, there is a new visitor, that there's an understanding of how people should be behaving in the workplace.
Yeah. No, absolutely. It's reviewing, monitoring, making sure everyone's getting the training. If you've got induction training for your staff, I think it should be part of that across all organisations, and sort of just being very clear. And when we're talking about training on that level, that's just to meet the threshold that we've got now. Really, it's obviously then going to have to be a part of the future as well, but it's also sort of very much trying to think about everything you can do. And in terms of what those likely relevant factors will be in terms of determining what is all reasonable steps for someone, well, we clearly need to look at the size and the resources of an organisation. A very small organisation with perhaps only one owner manager is probably only going to be able to dedicate a certain amount of size and resource to protecting people that work for them, whereas a big multinational company will have a much greater expectation on them to ensure that they really are doing everything and anything, that even if it is potentially at a great cost to them. The sector will be important. Obviously, we've touched on hospitality and certain other areas, or potentially certain roles within businesses. Unfortunately, sometimes people who have to deal with irate customers get to see the more negative sides of people's characters. So the role itself, as well as the sector, is relevant, and it's all about identifying the risks and thinking about the environment. And going back to your point, I think what better way of doing that than speaking to the people that this is designed to protect, to try and establish from them, well, where do you think you'll need the protection?
Keep that dialogue ongoing as well.
Yeah. Just moving on from that, the other change that's coming in April 2026 around sexual harassment is the fact that sexual harassment is now a standalone category, or will be a standalone category for whistleblower protection, in the same way as environmental hazards, health and safety breaches, and breaches of law have been. Now, you can look at this one of two ways. One way would be to say, oh, well, actually it's nothing new, in that whistleblower protection, probably if you were to make a disclosure about sexual harassment, the existing catch-alls around legality and things like that will probably ensure already that you have whistleblower protection. But actually, by having it as a standalone category of disclosure that is protected, you're really highlighting the importance with which this should be viewed now, I think.
Yeah, I agree.
And will hopefully encourage more people to make those disclosures, so you're not sort of delving within case law or knowledge of the law to determine, actually, if I make this disclosure, am I going to be protected? It is just explicitly stated. So that's I think a positive stance of doing that, and that will protect people from both detrimental treatment. So if they're punished in some way by an employer for raising that concern, that's a ground of action of itself. No one actually needs to be dismissed to have protection under whistleblower legislation. It's about detriments, but also dismissal itself on those grounds would give rise to actionable claim as a whistleblower.
I would say, to summarise as well, in terms of preventing sexual harassment, we see time and time again that things that have happened in the past, they do come to light at some stage.
Yeah.
So it's so important that employees and the employer take it seriously, and this further legislative arrangements are really reinforcing that to prevent it in the first place.
Yeah. One further final point that I just wanted to make is that it's also looking likely that there's going to be a future change that will void clauses in settlement agreements and things like that seek to prevent disclosures or allegations about workplace harassment being discussed Now, clearly you can see the reason why that people aren't then just pushed out of businesses and asked to sign settlement agreements that saying, well, you won't disclose the circumstances leading up to your dismissal, which may have included allegations of sexual harassment and so on. It's certainly not. You wouldn't have to look too far in the past at all, I would say, to find circumstances of victims of sexual harassment that have been forced out of businesses and paid off. So this is designed to still give them a voice, and as you say, if things have happened once in the past, you'd want to prevent them happening again through people raising and discussing them. So that's definitely the reasoning behind the change, I would have thought, and the plus side from it. The one thing I'm concerned about, if you like, for want of a better expression, around that kind of change would be, would it actually make it harder to resolve cases? Because in many cases where you have allegations of any sort, employers will want to sign settlement agreements and documents around confidentiality because they are concerned of those allegations entering into the public domain, and could be a big part of the reason why they're willing to perhaps offer someone a settlement payment or resolve an issue on more amicable terms. And if there is still the potential for someone to make those disclosures, are employers going to be more reluctant to pay as much as they might otherwise for a settlement agreement, or just enter into a settlement agreement generally? And that leaves people in a situation where actually you may have no choice but to go to a tribunal or bring a claim and things like that. And whilst there are obvious negatives from an employer for doing that, there's also quite a few negatives from the employee perspective that actually, if you've been the victim of harassment, you may not want to relive this, or you may want a resolution that allows you to move on and gives you some kind of outcome. So that's the bit that will need to be carefully managed, I think, around those. And on that note, I will draw this podcast to an end, and thank you very much for listening, and do keep an eye out for any further updates that we have around the changes that are coming in employment law.